prosecuted and convicted of that, but they could impeach him on that ground. And how does that work? They have to have 2/3 of the House to impeach. It's like a probable cause hearing. And then the Senate tries the individual who's been impeached. And there's a wide range of results. And then if it's a crime, that individual is still subject to criminal prosecution in the courts. You see how the attorneys are really messed up? That thing we went through with Clinton was a farce. Absolutely a farce. Questions? Yes?
Back to the Second Amendment. They do so much through the Commerce Clause to get federal control over stuff. What's your opinion on like the intrastate manufacture and sale of firearms?
Well, let's go back a little farther. What was the purpose of the Commerce Clause? What was going on at the time? Why did they put the Commerce Clause in the Constitution?
Tariffs between states.
Correct? You said tariffs between states. The states would add taxes and tariffs on goods going through the states. And Madison said that leads to war. We let this go on, we're going to, it's going to create conflict and eventually war between the states. And actually, that's what happened with the war between the states, if you understand what caused that war. But so they put the Commerce Clause in there to encourage interstate commerce, not to give the federal government this almighty power over them, and in fact to keep it regular. That's what it was intended for, not as it's used today. I'll have to quote this since I don't have the book in front of me.
Aren't they actually making interstate commerce irregular by doing what they're doing with the gun laws?
Well, first of all, I would encourage you to think about things this way. In the right hand, I don't do that significantly. In the right hand is the way it's supposed to be. In the left hand, the way it is. See how far they're apart? And they don't clap. They don't get together. All right? Most of what the government does today is over here, and it's not constitutional. And they don't know because they don't read the document. So the Commerce Clause, if you want to analyze what the Constitution actually means, you've got to do a couple things. You've got to get a dictionary that's written in the time. Noah Webster's 1828 is a good source. There are earlier dictionaries. But you got to understand what the words meant when they wrote them. Because that's what they mean today. Not what we think they mean. Not what attorneys say they mean. But what the words actually meant in the ordinary use of them. And then you've got to understand what was going on that prompted them to put those provisions in the Constitution in the first place, be it state or federal. All right? They were brilliant men. They knew about all sorts of government. And we don't have a democracy here, do we? We're supposed to have a constitutional republic. The rule of law, not the rule of the majority. So, in order to do that, go back and look what caused it. Just like was stated, there was this tension between the states because they were putting on tariffs, and the framers said we can't let that happen. So we're going to keep it regular. We're going to encourage this interstate commerce so it will grow. We're not going to put barriers. We're not going to put taxes. But the federal government was not intended to control much of anything. All right? Same thing with the Second Amendment. Tell me where in the Constitution, the body of the Constitution, something about guns is stated. They draw the Commerce Clause. They draw the Necessary and Proper Clause, or the welfare for other things. But the Commerce Clause is used. Now I guess they can use taxes, right? Because it's the Obamacare.
Yeah.
I have several papers on my website about that. That's totally unconstitutional, by the way, and I proved that. But the point being is, the issue of commerce is not involved. And if it were, then the only thing that occurred in the original states was to have commerce between each other in the states. How stupid would that be? Because there weren't that many people doing things in each state. So they needed to sell and buy from other states. The North had certain things, the South had food, that kind of thing. This is what our country is built on. And when our country is most prosperous was when the government was out of our lives. And that's the way it's supposed to be. Now, government has a role. Commerce Clause was intentionally expanded by certain attorneys and judges. And just a minute. You probably never heard about this group. It's the National Conference of Commissioners on Uniform State Laws. Ever heard about these guys? Attorneys and judges, professors of law, the only ones that can play. They first met in Saratoga Springs, New York in 1891. They celebrated their centennial, which is what this book is about, in 1991. No USB number on this. None. When I found it, actually I found it because a lady who worked in the Senate Library in Harrisburg and also for a senator, and we got to know her in the 90s. She was walking in the hall one day and she said, "You might want to look at this." And I kept on walking. Gave us 3 or 4 pages. I went to the law library and I found this book. And I began to read it. I said, wow, this is important. These guys make uniform laws. In other words, if there's a law in New Jersey they think ought to be all around the country, they write that and attorneys get it implemented. They do model acts, which is something they want to do to advance the agenda. But what's important, when I read this book initially, right at the beginning, it says, for the nation's first 100 years, the system of legal diversity worked fairly well. Although, in one sense, the Civil War grew out of a decisively non-uniform state law concerning slavery. That's not true, but that's what this is. But after the war, as the nation came together again, moved westward, expanded its borders, began to industrialize, and acquired the means of transcontinental travel, the need for a common, predictable, nationwide legal system became crucial. Now, aren't we supposed to be 50 states that are brought together in a union, a federation of states, where the states are supposed to be the creator, the primary, and the federal government has a limited enumerating power. These guys decided that wasn't going to work too well. So, they had the so-called 14th Amendment, so they decided we'll just change it. There were at least 2 methods for unifying the legal system of the states. State law could be preempted by the federal government through the repeal of the 10th Amendment, or by expansive interpretation of the Commerce Clause and other express power delegated to Congress. I didn't make it up. They wrote it. God bless their souls. They're compelled to write it down because they want everybody to know how great they've done. Right? And the more you read of these attorneys, it's really better than fiction. Anyway. Alternatively, the states could create a forum and a vehicle by which they could voluntarily agree to develop and then separately adopt uniform legislation on important subjects of common concern. That was a path chosen in 1891 when the conference was conceived. It is probably not coincidence that the origin of the conference occurred during the centennial celebration of the Bill of Rights and the 10th Amendment. I have called this in the paper treason. They were going to destroy the structure of government, and in fact, effectively have. They've not only done the alternative way, they've also virtually obliterated the 10th Amendment, haven't they? Who in the world thinks they can come into this state and tell you to do anything with your guns? None. There's no authority in the federal Constitution to allow them to do that. And the Second Amendment is a specific prohibition against them doing it, isn't it? Like the state constitution, there's a prohibition in Article 1, Section 21. Shall not be questioned. So, here we have their own words saying they're going to destroy our structure of government secretively by expanding the interpretation of the Commerce Clause. And they've done that very effectively. With the court's help. And a lot of it's done by the courts, by the way. The legislatures don't do it.
conducted business like they're allowed to do within their state, and every state had a firearms manufacturer and an ammunition manufacturer,
You could do that. Why do that?
then there would be no reason.
There is
to
no
call
reason.
in the
No.
commerce clause.
There is no reason anyway. You want to do that, that's fine. And that's one of the things they put out. They put out a bill, anything manufactured within the state and sold and bought in the state, then the feds have no authority. They have no authority anyway.
But that would be used in their false use of the law.
If you
The
want
right
to,
way.
if you want to do that, and I'll tell you what they'll do. What they'll do is they'll change it. All right? And then what you going to do? All right? The answer is they got no authority in the first place. Let's not give it to them. Not acknowledge that they have the authority. It's harder. There's a lot of things that people come up with to avoid the pain. Well, we got to sit them down and say the 10th Amendment says you can't do that. You can't do that. And what Matt Friend's case was all about. Let me read this. And I know everybody's getting tired of it. Get this book. Here's the order of the court in print. What was going on here? Federal government says sheriffs and chief law enforcement officers collect this data on people buying guns and give it to us at no cost to the feds. So here's Scalia writing the majority opinion. Quote, we held in New York. New York was a United States Supreme Court case in 1992. That Congress cannot compel the states to enact or enforce a federal regulatory program. Today we hold that Congress cannot circumvent that prohibition by conscripting the state's officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers or those of their political subdivisions to administer or enforce a federal regulatory program. See how powerful that is? Isn't your school board a subdivision of the state? And your county? The federal government has no authority to come in here and tell you what, the government entities to do something. I'll make the exception in a minute. It matters not whether policy making is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. Madison's dual sovereignty. Now, the dissenting opinion. Kind of 5-4 decision here. Here's the dissenting opinion, written by Stevens. If Congress believes that such a statute will benefit the people of the nation and serve the interest of the cooperative federalism better than an enlarged federal bureaucracy, we should respect both the policy judgment and its appraisal of its constitutional power. Punt. So what does Scalia call that? I love this. Here's Scalia's assessment of the dissenting opinion. The dissenting opinion, according to Scalia, says it's empty, formalistic reasoning of the highest order. So that's a judge's way of saying BS. Pardon my French. Point being is, this is good, because the catch is that if the state or the township or the school district takes a bribe, get federal money, right, which always gets cut off after a few years, right? They give you a little bit. Oh, if you want this, you've got to do this, this, and this. No child left behind. Now we have Common Core. That's all tied to a grant. And the governor gets the grant, and he can distribute a lot of it, and usually gets a percentage of it. This is a game that's so perverse and so fraudulent, it's sickening. All right? We send the taxes to the federal government, well, to the national government. And then they steal as much as they can and give you back a little. And oh, by the way, when they give you back a little, you've got to do everything they tell you. What kind of sense does that make? Right? My point is, we'll keep it. We'll give you what you need, if you can justify it. And the rest we'll use ourselves. Oh, there's some states that won't have enough. Well, I think the way it's supposed to work is you should go to your friends and to the church, to your community, but you don't go to government, because they're not in that business. Never were, not supposed to be. There's an article, which is an unknown author that I reproduced on the website, Not Yours to Give. It's about Davy Crockett. You ever heard that story? Get on the website. Jim Compton says, oh, everybody knows about that. I said, let's pass it out anyway. And he came back and said, did you know it? None of them knew about it. I said, well, that's the reason we're doing it. So the point being is, and he got a chance, he likes to talk with everybody, and so do I. So the point is, yes, Nick?
Yeah, I was just wondering, I hear you use, the term, they don't have the authority. Quite often, my question is, what's your definition of authority?
Where have you been tonight? If it isn't authorized by the state constitution or the federal constitution explicitly, they have no authority to do it. And if you read enough, thank you for coming, no, it's long. If you read the backup documents and the family documents, the commission notes and so forth, and the federal papers, the anti-federal papers, you'll find out that they all wrote it down, what it really means. And if I can read it, and you can read it, they can read it. In fact, it's their job to read it, particularly attorneys and judges. It's their profession. That's the crime of it. They should know better. They're not taught that all. They're taught, Christopher Cummings, Langdale case, that's what they're taught. That was done in Harvard in 1870. Okay? So the answer is constitutional law. Anything that is contrary to the Constitution is null and void from the time they did it.
And the county commissioner can make his mind up and...
Absolutely. He takes an oath, sir. You take an oath to support, obey, and defend the Constitution, right? And to discharge the duties of the office with fidelity. I don't see any pledge in any oath to a court decision or to a statute or anything else. It's to the Constitution. And if something is unconstitutional, if you don't know, then everybody needs to study before you act. That's what the oath of office means. That you're going to support, obey, and defend the Constitution. And everybody in government ought to do that. And this idea that the attorneys and judges have sold us on them. In Marburg versus Madison, the court decided that the only ones that can make that decision is the Supreme Court. Or courts, and then the Supreme Court ultimately. That's not what that case says. It says quite the contrary, and they just lie about it. It's everyone's duty, by their oath, to determine what they're about to do, if it's constitutional or not. If they've done something wrong that's unconstitutional, it's their duty to fix it. Now, that may seem a bit harsh, but that's the law. And if you don't do it, you're violating your oath of office, which, by the way, is a felony, both state and federal. Now, if you happen to be in the General Assembly, you can be arrested for it. I think people can be arrested for it, too, no matter. Felony is a felony. Now, you got to have a grand jury, you got to get somebody indicted, and so forth. Tough today. Because there's no consequence for those in government. They get away with it because the attorneys say, the commissioners have solicitors, right? And if you have a question, you say, Mr. Solicitor, can I do that? Now, he doesn't know. But he tells you you can do it, perhaps. If you read the solicitor's handbook, this is interesting. You read the solicitor's handbook. They say you've got to do everything according to the Constitution and the laws of this Commonwealth. And then in page 5 it says, as far as zoning is concerned, everything that they do in zoning, the basis is historically and culturally rooted. The basis of this cannot be found in the words of the Constitution. The basis of what they're doing in zoning cannot be found in the words of the Constitution. Unconstitutional, every bit of it. Now, I have a paper on there about zoning. You can spend a lot of time on the website. I have a new article every week, so. Some current subject, usually.
If the Constitution doesn't suit somebody, like an amendment to get their way.
There are very specific procedures for amending the state and federal Constitution. The federal Constitution has been violated since the 14th Amendment. Not been changed according to the Constitution. All right? The state Constitution has been violated since 1776. Not been changed according to the Constitution since 1776. I have a paper on that too. It's not on the website. I wrote it when I did research on that subject.
Because of the time commitment that we have here with the Genetti, the Q&A is over, but if you want to mill around and ask him any questions privately, you can take your time and do that, but we need to start to clear the room. No kidding. Thanks.
Thank you.
Thank you very much.